Hello everyone, Muskaan here, and in today's video we're going to be talking about consideration under the Indian Contract Act. So as always, whenever we discuss the Indian Contract Act, we're going to talk about what a contract is before we move on to the main topic, which is what is the meaning of consideration and how do we decide what a consideration is. Alright, so the most important thing to understand first is what is the meaning of contract. So Section 2 of the Indian Contract Act is what is the known as the interpretation clause that lays down all the definitions of the different terms that are generally used uh, under this law. And all these terms are connected to one another. So let's look at first what is the meaning of contract. That is given under Section 2H, and it's very simple. It states that a contract is an agreement enforceable by the law. Now, what is an agreement, you may ask? And that is given under Section 2E, which defines agreement as every promise and every set of promises which form the consideration for each other. So a contract is an agreement which is enforceable by the law. And when we look at what is the meaning of agreement, it's basically every promise which forms the consideration for each other. Now, two very important terms when we talk about contract is that of promisor and promisee. So the person who makes the proposal to another person is called the promisor, and the person who accepts the proposal is the promisee. Now we have new terms here as well. One is promise. We have to define what a promise is. We have to define what a consideration is, and we have to understand what a proposal means, right? Now those terms are defined under the following sections. First, we have promise under section 2B. This says that a promise is a proposal that is accepted. So, now a promisor is the one who is making the promise. So if I say that I am willing to send you X for Y amount of money, that is a proposal I'm making. Once you accept that proposal, then it becomes a promise. And since I am making the proposal to you, you are the promisee, right? Now we have proposal. This is given under section 2A. When one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of that other to such act or abstinence. So when I propose something to you, I am trying to get your assent to my proposal. No matter what I'm proposing, whether I'm proposing to do something for you or whether I'm proposing that I'll stop something that may benefit you, right? And finally, we have consideration. That is under section 2D. When, at the desire of the promisor, the promisee or any other person has done or abstains from doing something, then such act is a consideration for the promise. Now, we will study the definition of consideration in detail later, so let's leave that for now. Alright, now that we know that a contract is an agreement enforceable by law, agreement is every promise or set of promises that forms the consideration for each other. A promise is a proposal that is accepted, right? A proposal is when someone promises to do something or refrain from doing something in order to gain the assent of the other person. And a consideration is basically the payment for the promise, the object of the act. However, the other part of the definition of contract is an agreement that is enforceable by law. So this brings in section 10 of the Act, which talks about the essential elements of a contract. So what this says is that all agreements are contracts that are made by these following points. So unless these points exist, it will not be a valid contract in the eyes of the law. The first one is consent. There has to be free consent of the parties. If there is any coercion, if there is no consent of the parties, if there is fraud, if there is manipulation, blackmail, etc., then it will not be a valid contract in the eyes of the law. Second one is competence. So this basically means the parties that are involved in the contract are competent to contract. They have to be of sound mind, they have to be of major age, which is above the age of 18, and they cannot be insolvent, right? Then we have the third one, that is consideration. This basically says that there must be a lawful consideration. What do we mean by lawful consideration? The consideration itself has to follow the law. It cannot be an unlawful consideration. You can't say that I will murder someone in return for something, or I will steal this from someone in return for something, or I will force this person to get married to someone in return for something. All of that is not considered lawful. Similarly, the object also has to be lawful. And finally, it must not be expressly declared to be void under any law. So, if all of these things are present, then all these agreements are contracts in the eyes of the law. Provided, of course, that there is a promise, there is a acceptance, and there is a consideration. Alright, now let's move on to understanding the meaning of consideration. So we'll look at a few definitions by some jurists. The first one is Blackstone, and what he says is that consideration is the recompense given by the party contracting to the other. Now, what is the meaning of recompense? It basically means repayment. What he's basically saying is that consideration is like a quid pro quo. You're giving something for something in return. Similarly, Patterson says that consideration means something which is of some value in the eye of the law. It may be of some benefit to the plaintiff or some detriment to the defendant. Now, he's already said consideration is a repayment. It's a quid pro quo. Patterson is going ahead and talking about what consideration means in the eyes of the law. He's saying it has to have some sort of value in the eye of the law. Now, the important part is that it need not be adequate in the eye of like a normal person. If I say that I want to sell, if I say I want to buy your car from you for only 1,000 rupees, and you agree, now a lot of people might say it's not enough. A car is worth much more than 1,000 rupees, but a court might say that if both parties have willingly consented and I am losing 1,000 rupees to get your car, you are still getting some sort of benefit, I am still having some sort of detriment by that 1,000 rupees, right? So consideration just means it is something which is of value in the eye of the law. Then we have Pollock, who says consideration is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. So again, the same thing. He's saying that consideration is the price for which the promise is bought. Now, I'm making you a proposal, you are agreeing to the proposal, but you're going to give me something in return for that, right? I'm going to ask for something in return for that. So the consideration is the price being paid for the object of the act. And once the consideration is fixed, then the promise becomes enforceable, and that's how it becomes an agreement. And once this agreement is enforceable in the eyes of the law, it becomes a contract. So now that we understand the meaning of consideration, let's now look at the definition of consideration. Like I said, this is given under section 2D of the Act, and this is what it says in full. When, at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, then such act or abstinence or promise is called a consideration for the promise. So we're seeing several things over here. First of all, it has to be at the desire of the promisor, right? It must move and it must be done by the promisee or by any other person. So one, it is at the desire of the promisor, and the other point you can take is that it has to move from one person to the other. One of the persons involved has to be one of the people in the act, but it might also arise from any other person, right? Then we see that this act covers three different types of considerations. One is has done or abstained from doing. This is what is known as a past consideration. It has happened in the past. Next, we have or does or abstains from doing. This is what is known as a present consideration. This will happen right now. I'm going to give you something, you're going to give me something in return. That is a present consideration. Or promises to do or to abstain from doing something. This is a future consideration. If I say I'm going to give you this now and you can repay me in installments for the next few months, then the later considerations become future considerations. Then this act or abstinence that is being done is called a consideration for the promise. Now, as we've seen in the definition under section 2D, we saw there was a few points that I stressed on, and those come together to give us what is known as the essential elements of consideration. There are 4 such essential elements. The first one, at the desire of the promisor. That means only the parties involved can agree upon a consideration. So while the consideration can come from the promisee or from any other person, the agreement of what the consideration is has to be decided by the parties. Now, either I will say I will tell you I will sell you this for this much money, and I'm saying I want this much money as consideration, and you might come back with a counter offer and say I will give you this much money. And if I agree to it, that means we both have agreed on it. So it must be at the desire of the promisor, and only the parties involved can agree upon it. Second, it moves from one person to another. Now, the consideration has to flow from one person to another. There has to be an exchange here. This can be done either bilaterally or unilaterally. We'll look at what that means later. But basically, it can move from either the promisee or from any other person on behalf of the promisee. So under English law, for example, if you look at their contract law, only the promisee can give the consideration. If you tell me I will give you this money and you get somebody else to pay that money, under Indian law, that's allowed. But under English law, that's not allowed. Number 3, it may be past, present, or future. We already saw what that means. If it has been something that has already been done, say you find and return my wallet to me because I lost it and I didn't realize. And I tell you, okay, because you have done that, I will give you this much money. You finding the wallet was a consideration, and my money right now is what I'm promising to give you, right? I'm saying I'm going to give you this much money because you found my wallet. That is past consideration. Present consideration, what is happening right now? We make an exchange. I will sell you this for this much money. Both of the things exchange hands, present consideration. And future consideration, you pay me later, or you said, or I will pay you now and you give me the object later. That is future consideration. Then number 4, the consideration must be real, but it may not always be adequate. That means it can be inadequate. The courts are only going to check whether or not there was a consideration in order for the contract to be valid. They are not going to check about whether or not the consideration was a fair amount or of equal amount to the object. That is not their job. If something is being sold for a lesser value, that is not something the court is going to talk about, because that is between the parties. As long as there is free consent, the parties have decided upon it, then the consideration need not be adequate. However, it must be real, it must be tangible. There must actually be some benefit to one of the parties or a detriment to the other party. Now, we've already seen past, present, and future types of consideration. There are 2 other types of consideration that I mentioned once before. One is unilateral consideration. This means the consideration is flowing from one party to the other. So, if I say I'm going to sell you this for this much money, and you are saying, okay, fine, I will take that for this much money, then the consideration is flowing from you and the object is flowing from me. Bilateral consideration is where the consideration flows both ways. Now, this can be either with money, depending on how you look at it, or it can be like a barter. I'm going to say, I'll sell you this, I'll give you this object of mine if you give me that object of mine in return. So from my perspective, the object you are giving me is the consideration, but from your perspective, the object that I am giving you is the consideration. So it's like a barter system. The consideration is flowing from both ways, and the promise is also flowing from both ways. Now, we saw under section 10 of the Act that one of the essential elements of a contract is what is called lawful consideration. So how do we define what is a lawful consideration? Section 23 of the Act defines that. So section 23 focuses on object and consideration that will be lawful. So it states that any agreement's object and consideration will be seen as lawful unless one, it is forbidden by the law. So if the object of the consideration is forbidden by the law, expressly forbidden by the law, if it's, an actual civil wrong or a crime or an offense or something that is prohibited under the law, then it is not a valid consideration and is not a lawful consideration. Second, It is of such nature that if permitted, it would defeat the provisions of any law. So it might not be expressly forbidden by the law, but if it is allowed to be done, then it will defeat the provisions of any existing law. Say, for example, I tell you that I will sell something to you if and only if this particular horse wins at this race. This is not direct gambling, but if we are putting such an contingency on the thingy, on the sale, then it becomes, you know, illegal. It becomes a sort of gambling that defeats the provision of the law of gambling. Third, it is fraudulent in nature. This doesn't require much explanation. If there is any fraud involved in either the object of the consideration by either of the parties involved, it will not be considered lawful. Fourth, it involves or implies injury to the person or property of another individual. So if either the object or the consideration involves beating someone, stealing from someone, murdering someone, vandalizing property, etc., then that will not be considered lawful consideration. And five, it is immoral as per the courts. So the courts decide the consideration is immoral or it is opposed to public policy. So it is indecent or immoral in the eyes of the law or of the public. When we talk about lawful consideration, it's also important to talk about section 24. Now, what does this section say? If any part of a consideration for one or more objects or any part of more than one consideration for an object is unlawful, then the entire agreement is void. So it doesn't matter how many objects there are or how many considerations there are or how many parts they are divided into. If any consideration or any part of any consideration is seen as unlawful, then the entire agreement itself is void. You can't put in the doctrine of severability and say, okay, we'll just take out that portion of the consideration. It doesn't work like that. If any part of the consideration is unlawful, then the entire agreement will be deemed to be void. So now we know that the law specifically states that all agreements without consideration are void or invalid, or they cannot be considered as contracts, because consideration is an essential element of a contract. However, section 25 lists down certain exceptions to that rule. It says that an agreement made without consideration is void unless 1. It is made due to natural love and affection between parties that are related to each other. So this is what is termed as a gift. If two parties are related to each other and one party is gifting a property or an item or any sort of object, maybe money, to another, and out of natural love and affection between the parties, then it will be accepted as a valid contract and you can take it to court to be enforced. 2. If a person agrees to pay a debt where the limitation of suits has run out. And in this situation, if the limitation of suits had not run out, the creditor should have been able to legally enforce the repayment of the debt. So if it was a legally enforceable debt, but the limitation of suits has run out, and then the person who is in debt promises that even though the limitation of suits has run out, I will pay you back the money, then that will also be considered as a contract. In both of these situations, there's one important clause that they must be written and they must be registered under the law. So without being written and registered, it will not be considered as a contract. Then third, we have if it is a promise to compensate a person for a past consideration. This is where we take into account past considerations. This is the legal provision under which past consideration is allowed under Indian law. So like I said, the wallet example, if I lose some sort of item, a wallet or any other item, and somebody brings it back to me, and I promise to them that because you brought it back to me, I will pay you this much money. That you bringing it back to me becomes a past consideration, and my promising to pay you that money right now is the proposal that I'm making. So once I made that statement, I can't go back and say, no, I'm not going to pay you, because then that person can take me to court and say, he promised to pay me for this past consideration and I deserve that reward. Fourth, if the promiser has made a promise to a promisee who then relies on that promise to their subsequent detriment. So now if I promise something to you and based on what I've told you, you go ahead and make a contract with somebody else, and then I don't follow through with a promise, or there is no direct thing here and it falls to your detriment. Maybe you haven't made a contract with someone. Maybe you have acted on my words and you have gone ahead and done something which has made you lose money. Something like that. So even in that case, even though there has been no consideration decided between us, I have still made you a proposal or made you a promise, and you have accepted that and you have used that, and then there has been no consideration that has been given from your side. It will still be a valid contract under law because I will still be liable to compensate you for whatever detriment that you have faced. Okay, so now we've reached the end of today's video. I hope you all understood what a consideration is. To recap, a consideration in any agreement is one of the essentials that form a contract. A contract is an agreement that is enforceable by law, and in order for a contract to be a contract, there must be a proposal. The proposal must be accepted, so that it must have become a promise. There must be a consideration. It is one of the essentials. It is basically the price that is paid for the promise, right? It is something for something. It's like a quid pro quo. It must be real, it must be practical, it must be lawful, but it need not be adequate. And finally, an agreement made without a consideration is generally considered to be void, but there are a few exceptions that are given under section 25, 4 exactly exceptions given under the section, wherein an agreement without a consideration may still be considered to be a contract. So now we've come to the end of the video. I hope you've understood. Thank you so much for watching. Please like and subscribe and stay tuned for more. And goodbye.